So, very good evening, dear friends. Yesterday, I covered sections 241 to 246 with other provisions pertaining to the prevention of oppression and mismanagement under the Companies Act 2013. Today, I will give you some important definitions. What is the meaning of oppression? What is the meaning of mismanagement? And then, in fact, the minority shareholders question the mismanagement, then they will be put on oppression. This is how things move on. And then there are a number of permutations and combinations of the subject matter, of course. Very interesting it is. First versus Harbortel does not apply here. This stands as an exception. Time and again, I'm telling you about that. So, in that regard, we will go through now the important, the particular definitions and then other issues pertaining to this particular subject matter. So, friends, primacy question comes: what is the meaning of oppression? Companies Act has not given, but the related terms are oppressed, oppressor, oppressful, oppressing, oppressingly, oppress, oppressively, oppressiveness, oppressment, oppressor, and oppressor. These are all the different nouns for this particular subject matter. And then this particular word, actually, interestingly, it is found that it is traced as back as 12th century. And according to Oxford Dictionary, the meaning has been given what I have told you just now. And among the several meanings, the meaning related to the subject matter is exercise of authority or power in a burdensome, harsh, or wrongful manner, unjust or cruel treatment of subjects, inferiors, etc., the imposition of unreasonable or unjust burdens. This is the most important subject, in fact, pertaining to this particular oppression. Then, further, the act of forcibly putting down or crushing repression. Actually, Bentham has got a great works in 1843, and then he classified the enemies of people as depredationists and oppressionists. And he says the depredationists are those whose love of themselves is stronger than their hatred to others. Love of themselves is stronger than hatred to others. They are some comparatively better. And the oppressionists are very difficult people. Those whose hatred to others is stronger than their love of themselves. That means hatred to others is stronger than their love of themselves. This is where the whole problem comes up. Disputes will arise. In this particular subject matter of prevention of oppression and mismanagement, if the depredation is, then they will create problem. So a person who causes oppression to others is an oppressionist. And the meaning of the term oppressionist, and then the Oxford Dictionary states that one who practices or approves of oppression. Whereas on the meaning of the term oppressive states, pressed down, burdened, troubled, depressed. And further, oppressively, the very meaning is unjustly harsh exercise of authority or power, tyrannical. So, friends, the word oppression has got a very far-reaching consequences in corporate democracy and corporate governance today. And in a company, specifically on a particular proposal, in the shareholders' body, there are supporters as well as dissidents, and the supporters cannot forcibly attain their objective by snubbing the dissidents. Applying fast versus hard bottle rule won't apply. In fact, it is not valid here. The dissidents can be majority or minority also. Sometimes the minority will, in fact, oppress the majority. That also happens. Sometimes even a minority can resort to using oppressive measures against majority. LIS of India versus Escorts Limited, 1986-59 company cases, 548, most important judgment. Supreme Court. And for smooth functioning of corporate democracy, the supporters of an issue must strive to convince the dissidents to accept their view, but they cannot force their way by tyrannically approaching the minority or otherwise, which gives rise to cause of action and involves the provisions under section 241 to 246. Friends, there are certain important judgments where I will, some important textbooks also dealing with this subject matter. One is Venkatramaya's Law Lexicon and Legal Maxims. This is second edition, revised by Justice M.C. Desai, all High Court, Allahabad High Court. The term oppression is described that there has been disregard of the essentials of justice and the infliction of penalty. Then, friends, in Stroud's Judicial Dictionary of Words and Phrases, the particular term has been dealt with as the term oppressive is interpreted with reference to section 210 of old section of English Companies Act 1948 and having its ordinary meaning of burdensome, harsh and wrongful. And then quoting the decision in Re 5-minute car wash service 1966 1 WLR 745. It is further interpreted as to establish a case of oppression within the section 210 referred above, and that it had to be shown that those who are alleged to have acted at least unfairly. Simply an allegation is not enough to prove that they had been unwise, inefficient, careless. The unfair conduct has to be expressed. Then the Supreme Court in Stewart versus Cormac 1941 SCJ 7377 has also dealt with this aspect, stating that there should be vindictive conduct, and then it may be upon some misleading statement of facts put forth, so that has to be taken into consideration. Then the law lexicon, the Encyclopedia Law Dictionary with Legal Maxims, compiled by P. Ramanath, 1993, Vadhva. The word oppression is defined as act of cruelty, severity, unlawful exaction, domination, or excessive use of authority. Then, friends, in Legal Thesaurus, William C. Boughton has written, 1980, New York, Macmillan Publishing Company. The relative term oppress is interpreted as abuse, victimize, badger, bail, brutalize, coerce, constrain, restrain, contempt, discommode, dominate, exploit, take advantage of, harass, relieve, mistreat, overload, persecute, plague, pressure, prey, subdue, subject. In fact, I have given you the reference. You please check the reference, you will find all this there. The Corpus Juris Secundum of United States, Volume 67, 1978 by Arnold O. Jimnow and George Gordon, sent to Paul Min, West Publishing Company. The word oppression is interpreted as to crush, burden, or trample down by abuse of power of authority. So, friends, in Halsbury's Laws of England, the term is taken as, in the context of section 210 of the Old Companies Act 1948 England, it's stated to be burdensome, harsh and wrongful. So all this tells you as to how this particular word oppression has got such high recognition from the judiciary, especially in corporate democracy. Then the earliest of the decisions of oppression in India were brought into force. Yesterday, I think I referred to 1951 Companies Act, but actually you have to see the originating provisions happen to be sections 153C and D to Companies Act 1913, originally, not earlier 1840, 1913. Subsequently, the 1951 Amendments Act has come Subsequently, the 1956, then 2013, where AIR 1932 PC1, the Privy Council in a Ripon Press and Sugar Mills Company Limited versus Gopal Chetty observed that the fact that Venkatrao had a prepondering voice in the company by reason of his owning or controlling larger number of shares was of itself no reason for winding up of the company. Oppression has to be proved beyond reasonable doubt. Equally, another important case, Scottish cases 49 1952, that is the Elder versus Elder and Watson Limited, where Lord Cooper observed the essence of the matter seems to be that the conduct complained of should be of lowest, involve a visible departure from the standards of fair dealing and a violation of the conditions of fair play, on which every shareholder who entrusts his money to the company is entitled to rely. So, friends, I'm giving you a great hint. Avatar Singh would help you, Ramaya will help you, Datta on Companies Act will help you, Taxman Majumdar will help you to get a detailed grip over this particular subject. But important cases and citations I'm giving you so that it would be of great help to you in the examination. In the same way, English decision, Scottish Cooperative Wholesale Society Limited versus Mayor, 1959 AC 324. Lord Simons observed that oppression as that the complaining shareholder must be under a burden which is unjust or harsh or tyrannical. Then the Supreme Court of India in Shanti Prasad Jain versus Kalinga Troops Limited passed a landmark judgment 1959, 35 company cases 35 in Supreme Court, where it has referred to four English decisions, Elder versus Elder and Watson, George Mayer versus Scottish Cooperative Wholesale Society, Scottish Cooperative Wholesale Society Limited versus Mayer, and H.R. Harmer Limited, and accepted the meaning of oppression to be burdensome, harsh, and wrongful. And the Justice Wan Chu, who became Chief Justice of India later, cited with approval the meaning of term oppression as explained by Lord Cooper in Elder versus Elder and Watson. So what are the examples of oppression? Now we will come to that. Shanti Prasad Jain versus Kalinga Troops Limited. Now Supreme Court decision AR 65 SC 1535. The Supreme Court said it should involve at least an element of lack of probity or fair dealing to a member in the matter of his proprietary rights as a shareholder. In Fielders Brothers Limited, the Chancery Division, 1971, All England Reports 923, Chancery Division. To prove oppression, the court said it must go beyond what is required to make out a case for a winding up order and must indicate some lack of probity or fair dealing towards one or more members of the company. The same principle will apply today also, 241, 242, 243. I told you yesterday, the same analysis applies even now. Then the second instance is the Madras High Court said in KRS Narayan Iyengar versus T.A. Mani. And then this is again a landmark judgment. And then this is AIR 1960 Madras High Court 338, where it was held that there should be overwhelming desire for power and control in the criteria to be established to prove oppression. Then an act of omission to achieve some unfair advantage also could be taken as oppression. 5-minute car wash services limited of English Code, in fact, dealt with this particular subject matter. The usage of assets of a company in other business also could be taken. This is decision of Hindustan Cooperative Insurance Society Limited. That is the Calcutta High Court has said in 1961. 31 company cases 193, Calcutta High Court. In the same way, passing of a resolution prejudicing the interest of company or shareholders. The Kerala High Court said A.M. Varke versus J.R. Motisha. A.R. 1964, Kerala 114. Then, friends, the unreasonable refusal of transfer of shares was dealt with in Mrs. Gajnibai versus Patni Transport Private Limited by AP High Court, 1965, 2 Compila Journal, 234, Andhra Pradesh. And overthrow by physical force of minority was dealt with by English case 3 5-minute car wash services limited. Then further, it is stray incidents is not permitted. Actually, one has to see the, in fact, oppression must be of a continuous nature. That is Shanti Prasad Jain versus Kalinga troops. AR 65 SC 1535. Then another example, destruction of companies' business by use of controlling power. Scottish Cooperative Wholesale Society Limited versus Mayor dealt with this particular subject matter. Then, friends, the inefficient management was dealt with by Calcutta High Court in Kanika Mukherjee versus Rameshwar Dayal Dubey. 1966, 1 Company Law Journal 65 Calcutta High Court saying that inefficient management will not amount to oppression and that can't be taken as a reason for taking action against them. 241 cannot be invoked. Isolated acts also cannot be taken into account. So, friends, these are all the basic issues which has to be taken. Shanti Prasad Jain versus Kalinga troops, that is AR 1965 SC 1535, landmark judgment, in fact, that would help you to understand this subject. With this background, we will come to the other aspect, that what is mismanagement. Now, mismanagement is concerned. In fact, the judicial interpretations come to, as I told you, a person objects to the mismanagement and then he would be put on oppression. So the Oxford Dictionary defines mismanagement as bad or improper management or administration. Law Lexicon says, Webster, quoting Webster, that meaning of mismanagement as wrong or bad management. Stroud's Judicial Dictionary of Words and Phrases, mismanagement is referred to as denoting commission. This is distinguished from inattention, which is meant as omission. Mismanagement is also stated to be willful or culpable neglect. Here it is not omission. It is commission with culpable or willful neglect. This is the most important aspect. You have to understand that particular aspect. In this context, I draw your attention to the meaning of management to understand mismanagement. Because the great Peter F. Drucker, the great expert, defined management as follows. This was in American Journal of Sociology, January 1953. Also quoted in the Dictionary of Sociology by William P. Scott, 1988. Now, what Peter F. Drucker says, I request friends, please put off your mics. It is getting disturbance. Management is the process of planning, organizing, coordinating, and directing the productive process in an economic enterprise. The term is also applied to those persons organized in a hierarchy who carry out the management process, that is, who performs these tasks or functions. The management hierarchy of a formal organization derives its authority and its responsibility squarely from function, that is, from its status relationship to the organization, and not from anything it possesses, such as property, birth, inherited magic power, or military force. Nor does it derive its position from the authority of superior knowledge or through socially accepted objective tests of achievement or accomplishment. In other words, it's not based on the standing of a profession. Its position, its power, and its responsibilities rest solely on indispensable function. This is equally true incidentally in a free enterprise society such as ours, as in a society of democratic socialism or in a totalitarian state. So anything which is against this, I can say, is mismanagement. So Peter Drucker has in fact made out a very good, analysis of this subject matter. Then the American Corpus Juris Secundum, volume 58, speaks of this particular mismanagement as wrong, bad, or bungling management or maladministration. And then mismanagement is not uncommon fault or shortcoming, and it does not impute embezzlement or misapplication. It has been held to be synonymous with misconduct and has been distinguished from inattention. The term misconduct has a broad scope, and a wide range of meaning according to the different connections in which it is used. It has been repeatedly construed by the courts in connection with matters concerning a deviation from a fixed duties or definite rule of conduct. This is most important. As a noun, both in law and in ordinary speech, the term misconduct usually implies an act done willfully with a wrong intention and conveys the idea of intentional wrongdoing. The term implies fault beyond the error or judgment. I hope now you understand. Uh, this is my research paper, Ph.D. subject. I have taken the legal perspective, judicial interpretations of the subject matter, which is in fact a management subject. So this is called interdisciplinary study, right? So, in fact, it is violation of definite law, a forbidden act, a dereliction of deviation from duty. So, friends, in the United States, the corporate law imposes a rule called business judgment rule, according to which the decisions by directors and FIs are subject to business judgment rule, under which the courts will not interfere with good faith decisions made in the exercise of business judgment. The rule may apply to a failure to act, but only if there was a conscious decision not to act. This rule acts as a shield against personal disability and also precludes the issuance of an injunction or declaratory judgment. This is the intellectual projection of law and its interpretation and analysis. That is how you have to view this subject matter. Because next year by this time you will be busy in writing your thesis. So naturally this kind of analysis is required, and interdisciplinary study also is required. So friends, this rule is inapplicable in the absence of good faith and disinterestedness. In the case of a closed corporation, the rule does not render conduct immune from scrutiny as a claim of oppression of minority shareholders. Thus, any acts committed against this rule can be viewed as acts of mismanagement. So, friends, in fact, I would like to take you to various judicial interpretations of this particular rule, and you can take this particular lecture as part 2. Part 1 is on provisions of law. Part 2 is on oppression, judicial interpretations, and then the meaning, dictionary meaning, interdisciplinary study, and the meaning given by the courts in London as well as the United States. Now the next one is mismanagement. This is also part of the provisions under 241. Under this particular provision, what you have to understand is that this particular analysis has to be taken into account. Now in part 3, coming part, immediately I will start off. We will deal with the judicial interpretations. So I will now take up that in part 3. Wait a moment, because now 24 minutes, the time will be out and then it will collapse. So to avoid that, to restart and then recharge with 30 minutes, I will go back and come back to you. I will put off and come back to you, and I will take this is as part 3, judicial interpretations. Thank you. Stay back. I will be back very soon. Thank you. Thank you.